Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, so I apologize.
Thank you, Your Honor. Today is the time and date for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with the bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared.
Right from the start, he admits to breaking the terms of his bond by drinking alcohol. But things take a turn. It wasn't just any drink. He tried to shift the blame onto Odo, the non-alcoholic beer. Sounds suspicious already, doesn't it? And this is just the beginning. Now, wait a second. Did he really say he forgot?
Violating his bond by consuming alcohol on July 7th.
Oh. And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
To mention the beers? That's like telling the tax office you accidentally left out a whole paycheck. The judge isn't convinced, and frankly, it's hard to be, then. The judge does a quick calculation. 25 ounces downed in under an hour with no bathroom break.
You tell everybody O'Doul's.
I had O'Doul's first, but I needed beer.
You had O'Doul's?
Yeah. I don't look like one of them.
No.
I had O'Doul's.
Are you tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted beers, but yes.
What?
I omitted.
Hold it. You know what, sir? Don't play fast and loose.
I got the story. I consume alcohol.
I know that.
You lied to me.
Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass it.
Yeah, I would be too. Because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour in order to reach that level. And could not have used the bathroom because you couldn't eliminate in order to get to that level.
At this point, the courtroom feels more like a stand-up show, and he's the punchline. You've got to admire how sharply the judge lays it all out clear. Direct, and with just enough sarcasm to make the point. Next comes the defense. He's a business owner, a family.
Your story was. And now you can't even. You can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice of that, quite frankly. Mr.
Yeah.
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question, and then asked him the question of why didn't he tell them, and he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of it.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a self-sufficient and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court-ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be...
Man, a volunteer. He says he wants help. It's the usual appeal for leniency. But the judge only cares about one thing, honesty. And based on what we've seen so far, his credibility isn't doing him any favors. Would you trust him to follow the rules with just a monitoring bracelet?
And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His scandal, I think it's just a couple of years. We would note that in this case, he allegedly not only that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I do.
The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remaining.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Hayward.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here. That's right. This is the one that. Hang on a second. Sure, this is the one that I looked at. All right. We have a plea form in this case. The defendant would be pleading to the charge of use of a controlled substance. I don't have. How come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No. You know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort. But I'll take it.
I appreciate Ms. Mackey because she provided me the basic law. This is a wolf. I think we're both involved here.
You just don't.
Provided me that they mostly typed out the form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
It's not myself.
Correct.
I appreciate Ms. Mackey doing my work for me. I'm not going to stop there.
So she half did it.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that.
Now we move on to the next case. Right away, there's a problem missing penalty details on the plea form. The defense says it was a team mistake, but the judge isn't amused. Honestly, these courtroom mix-ups reveal just how stretched thin the system really is. Makes you wonder how many of these small errors end up changing outcomes.
Term penalty on the one. Pardon? 1 year, 2000. It was a group effort. I like how they all sat there and tried to protect each other. All right. May I have him sworn?
I was sworn to affirm the testimony you're about to give the truth, the whole truth.
Self you got. I do. State your name. Devon Hayward.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that, sir?
I do, Your Honor.
You understand what a no contest plea is?
Yes, I do, Your Honor.
All right. Two things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I am.
You understand also, sir, that while I'm taking your plea, I would not be sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or
I am. I'm on probation. Explain the case.
well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 2442704. Any objection to the court having reviewed that report?
None from us, Your Honor.
Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
None, Your Honor.
All right. The court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be August 14, 2025. What time? 10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case, People versus Derek Stevens.